Good afternoon, everybody. We're going to start the court lecture today. Article 3 of the Constitution gives us the natural framework for the Supreme Court. It does not, it's the shortest article of the Constitution. It does not give exact instructions on how the court should behave. It just calls for the establishment of one Supreme Court and establishes that court's jurisdiction. And then which types of cases are original jurisdiction and which are appellate jurisdiction. Now, original jurisdiction is a case that is heard for the first time. The issue has never been tackled before in a court, and it is the first time that the court is actually going to make a ruling on that particular issue. Appellate jurisdiction is where the court hears a case on appeal from the lower court and may change the lower court's decision. The Constitution limits the Supreme Court's original jurisdiction to those rare cases of disputes between states or between the United States and foreign ambassadors. And for the most part, the Supreme Court serves as an appellate court. We'll talk about why that's important in a little bit. Congress then built out the rest of the court jurisdictions. Let's see. Hamilton says in the Federalist Papers that interpretation is a key role of the court as they seek to protect people from unjust laws, but also believe that the Judiciary Department would be the least dangerous. The reason that he believed that the Judiciary Department would be the least dangerous of all the branches is that it didn't have any power over the military, and there's no money in the court system, so it should be influenced much less by those influences that say protect Congress or an individual lawmaker. The court, therefore, could not directly take action. You could argue that's not the case anymore, especially as the politicization of the country has led to a skewed Supreme Court, but we're not getting into that today. The judiciary had a problem early in its day. The Supreme Court had to find where it belonged, I guess, in the terms of the congressional or the constitutional framework of the new country. So the Congress gave the judicial branch a basic structure. The lowest level are the district court, where federal cases are tried, witnesses testify, and evidence and arguments are presented. Like the cases that are going on right now with Ahmaud Arbery and Kyle Rittenhouse. A losing party who is unhappy with the district court decision may appeal to the circuit court, the U.S. Circuit Court of Appeals, where the decision of the lower court is reviewed. Once it reaches the circuit courts, you can then appeal it to the Supreme Court if you don't like the appeals court decision. The problem with that is, and we'll talk about how the Supreme Court selects their cases in a minute, but the Supreme Court gets thousands of petitions and selects fewer than 100 a year. So 1/10 of the total, the petitions that they hear are actually received by the court. Again, the court in its early days was trying to find its way early days, the Supreme Court did not have its own building, but instead shared a room with Congress. William Howard Taft, in the 146th year of the court's existence, urged for a building to be constructed. The Chief Justice of that court was William Howard Taft, who, fun fact, is the only person to go from the presidency to a different branch of government and also be the head of that branch as well. He was Chief Justice of the Supreme Court after he was president. There were early decisions by the court that helped kind of define what the court does now. Let's see, the 11th Amendment problem. I'm not going to do that one. The 11th Amendment says the judicial power of the United States shall not be constrained to extend to any suit in law or equity, commenced or prosecuted against one of the United States by citizens of another state, or by citizens or subjects of any foreign state. This particular power was the court or was the Congress saying that we can change your jurisdiction anytime we want to, and we will if we have to. Let's see. John Marshall is the second Chief Justice of the Supreme Court. The Marshall Court will define what we know today as the modern Supreme Court. What we know the Supreme Court to be famous for now is judicial review. The power of judicial review is the power of the courts as part of the system of checks and balances to look at actions taken by other branches of the government and the state to determine whether or not they are constitutional. If the court finds an action to be unconstitutional, it becomes null and void outside of a congressional, any kind of congressional legislation that fixes the problems that the court highlights. Marbury versus Madison is the first instance of judicial review. In that case, it was the dispute between the outgoing presidential administration of John Adams and that of Thomas Jefferson. Yeah, you don't even know that. Read about Marbury versus Madison, but it's not important that you know for the test or anything. So, in essence, judicial review gives the court the right to say that any legislative or executive action at the federal or state level inconsistent with the Constitution or a state constitution is subject to federal judicial review. The courts are not ready to just throw out laws willy-nilly, though. Marshall put it is emphatically the province and duty of the judicial department to say what the law is. They do not, the courts in this manner do not shape law. They are not meant to be activists from the bench. They are meant to simply interpret the laws and as such, not attempt to create policy from the bench, basically with their president. The common law system in the United States is largely developed combining judicial decisions. Roots in medieval England, the system was inherited by the American colonies, along with many other British traditions. It stands in contrast to code law systems, which provide very detailed and comprehensive laws that do not leave room for much interpretation and judicial decision making. With code law in place, It is the job of judges to apply the law. But under common law, as in the United States, they interpret it. Judgment law, accumulated law, or common law provides the opportunity for the judicial branch to involvement in the process of lawmaking itself, largely through the interpretation on a case-by-case basis. This sets the system of precedents that we currently have. Uh, Once a court hears an issue under its original jurisdiction, that precedent then carries forward to every issue that follows it. So every court that follows it under an appellate manner will do so under the idea that with the law that preceded it, that's how the rulings are going to go in everything that follows until legislation. The courts do not have the broad consideration of policy or cost and benefits. They simply uh, consider what is instead of the bigger worldly questions. Uh, um, let's talk about freedom of speech. When we talk about the court systems, we talk about the rights of individuals. And everything, like the freedom of speech, is inherent to every person in the United States with some limits. Changes in the way that the internet works, the way that social media works. The founders could not have interpreted when they wrote out the freedom of speech uh, amendment in the Constitution, the First Amendment, that Facebook would exist, that Twitter would exist, or any other type of modern technology. So freedom of speech has to be interpreted through the lens of what the courts and society, through the courts, believe is relevant. So rights are rights until they're not. Basically, is what I'm saying with that. You can't yell fire in a crowded theater, which is not a good example, and I can't remember why exactly. You can't make terroristic threats, not even if you're joking. You can't slander and libel laws exist as a check on the First Amendment power. Um, the Second Amendment the same way. The right to bear arms shall not be infringed has been interpreted different ways. Uh, it is said that the individual right to bear arms does exist inside of the Constitution, but the actual way that the jury, or not the jury, the justices on the court wrote the decision, they said specifically that while the right to individually own a firearm exists, there are state laws that are okay and sometimes necessary in order to make sure that society as a whole uh, continues. There are some regulations at the state level that are necessary in terms of the court system is supposed to be seen as a court of last resort. Uh, the court system is supposed to be the place where you go to find justice. It gives the citizen or group the opportunity to approach different institutional venues in the United States system and challenge them. Um, the court system serves as a more minute area where things can be brought and challenged at a very specific level in our society. Um, Civil Rights Act there. Now again, as we go throughout our history, the original document of the Constitution said slavery was okay, that owning another human being was okay. Obviously, we fixed that, at least in the text. We might not have banished it entirely from our society, but we have fixed it in terms of the text. As we continue along our path in the United States, laws, attitudes, society itself are all going to change at their own varying degrees and paces. As they change, it is up to the court system to keep up with those changes. Two of the bigger issues that show this divide are handguns and abortions. The left doesn't believe that everybody should be able to own a handgun. The right doesn't believe that everybody should have rights to an abortion. Those individual issues are it's up to the court to decide what is legal, what is not legal, what is societally acceptable, and what is not. The courts help do this. The Supreme Court especially helps do this. There are several, there's a Mississippi law on abortion that is currently on the docket for the Supreme Court. I think the opening arguments have already been heard. There'll be more deliberation in December. Usually we get decisions from the Supreme Court in June. I think there are several gun control laws on the docket this time. There are a couple of civil rights cases on the docket this time. There are cases in front of the Supreme Court right now that could fundamentally alter the way that our society has behaved in the last 60 to 100 years. All of that could change next summer. We'll just have to kind of see. I'm going to do the dual court system in the second lecture. So I'm going to skip ahead to 13.3 and talk about the federal court system. Now, there are three different layers to the federal court system. There is the lowest tier, which is the district or trial court. Then you have the Court of Appeals at the second level, which is the circuit courts. And then the highest court is the Supreme Court. That is the be all end all of all courts. At the federal level, decisions that are made inside of the federal courts set the precedent for all law and all courts across the country. Let's see. Now there are other more specialized courts. You know, there's Again, we're talking about president or sorry, decisions. Latin for stand by things decided, which means that today's decisions are based largely on rulings from the past, and tomorrow's rulings rely on what is decided today. Precedent is important in courts, but is not, when I say precedent, precedent also has to be weighed against the material evidence inside of the court being tried. Not the societal concerns, but the individual decisions made inside of the court itself or inside of the immediate case. So there are ways that precedent can change, but only when the facts of the case take it there. The selection of judges, we talked about this. Presidents are the ones that are in charge of filling the federal judiciary. One thing that I don't like hearing is he's a Bush appointee, he's an Obama appointee, he was appointed by Ronald Reagan, he was appointed by Barack Obama, he was appointed by President Trump. You don't like hearing those political undertones when you're talking about the court system. In a perfect world, politics means absolutely nothing to the courts, but we do live in a society that exists with liberal and conservative judges. Now, whether or not those judges rule that way is entirely up to them, and they're susceptible to the same impeachment proceedings as any other federal employee is. Same process as the president. Judges have been impeached before and been removed before for not upholding their oath of office, which is to serve, protect, and defend the Constitution of the United States from their bench. Now, it's not great to hear, like I said, the president that appointed the judge before talking about the actual judge. Politics, again, I'm going to say this one more time, should never be the reason that a judge is favored or disfavored. It should always come back to the law. It should always come back to the Constitution. That's one thing that all political parties should be able to agree on, is that at the end of the day, the law is the law. And that's it. There's no more to that sentence. The law is the law. Federal court judges and Supreme Court justices serve as long as they want to. They have lifetime appointments once they're on the bench. They can serve until they die if they want to. They can retire early, like Justice Kennedy did. Not Kennedy, Breyer. One of the justices that retired during the Trump era and got Amy Coney Barrett on the court. Now, if you want to flip back to the presidency for a second, Supreme Court judges are some of the most highly coveted things in politics in Washington. For a president, for the president's party, it doesn't matter. You want to be able to support and get your judges onto the court. You want your philosophy on the court so that you can uphold your legacy. That's a president speaking, not the judgeship itself. Again, politics shouldn't come into it, but when talking about a president, everything's politics. Everything's image, everything's legacy. So a failed nomination by a president to put a person on the Supreme Court is often deadly to to a president. Now, let's talk about the Supreme Court in general, or specifically, excuse me. There is one Chief Justice. This is the structure of the Supreme Court. One justice who is the lead or the highest ranking judge on the court, and then 8 associate justices, all 9 serving lifetime terms after nomination and confirmation by the Senate. We got a pretty diverse, well, we had a pretty diverse group of individuals. Let's see, Alito was the one that I believe retired. Yeah. Yeah, I think it was Alito. It must have been Kennedy. No, no, it's Alito that retired. And then Bryant, I don't know. I can't remember. I'm sorry. Not important. So again, presidents have the right to nominate Supreme Court justices. The Senate can or cannot hear those confirmations. If you didn't see the hypocrisy between Obama's nomination process and Trump, like President Obama tried to nominate a Supreme Court justice with eight months left in office. Mitch McConnell did a song and dance as the majority leader of the Senate, saying, "We are not going to elect a new justice to the court until after the presidential election." Ruth Bader Ginsburg dies with less than 2 weeks to the presidential election in 2020. They got Amy Coney Barrett confirmed that week. It's just hypocrisy. And if you look at the what was it? The comments made by Lindsey Graham between the 2 times, it's just straight hypocrisy. It's interesting. So anyway, the thing about Supreme Court justices is that while they do have a history of different judicial decisions, that does not necessarily mean that they're going to vote a certain way or guaranteed to vote a certain way when they get to the court. They do not work they do not seem to work anyway in an ideological bubble. They consider each case as they come to them, and again, hopefully, they look at each case with an uncritical eye. When they select cases, they put it on the schedule of cases is called a docket. The court, like I said, generally selects less than 2% of the total, or less than 10%, as much as 2% in some cases, of the cases that are actually given to them. When a petitioner petitions the Supreme Court for a decision, it takes 4 of the 9 justices voting to accept the case for the court to be placed on the docket. This is called the Rule of 4. The writ of certiorari I'm just going to go with certiorari. because I know that's not how you say it, but I'm going with it. There is a method to the madness that you can see inside of the cases that the court decides to take. If interest groups are actively pushing the case forward, it's more likely to get consideration in front of the high court. If the public and the media give a case attention or give an issue attention, it is more likely to get some attention from the high court. Enter at this point another key figure in the court system, the Solicitor General. The Solicitor General is the lawyer who represents the federal government before the Supreme Court. He or she decides which cases in which the United States is a party. That's important. He's the lawyer for the United States, in which the United States is a party should be appealed in the lower court, and personally approves each one presented. Most of the cases that the Solicitor General brings to the court will be given a place on the docket. The Solicitor General also decides what stance the court or what stance that the United States government will take in the actual arguments. Are they for or against? And they can also influence whether or not the court declines a case. They have that power as well. Now, I say power, influence, strong influence. The court does not always follow the advice of the Solicitor General or follow the demands of the Solicitor General. Demand is not a good word, but the Solicitor General has a good amount of sway in the process. Okay, so once the court is on the docket, briefs or short arguments explaining each party's view of the case are submitted, first by the petitioner, then by the respondent. After the initial briefs have been filed, both parties may file subsequent briefs in response to the first. There is also something called amicus curiae, or friend of the court briefs, which are given by outside influences, giving analysis, opinions, and recommendations about how the court should rule. Interest groups can become involved in this, and also private citizens in some way. Even if the United States is not a party of the case, the Solicitor General can also offer a brief and a guiding hand on where the court should fall on the issue. When the briefs are filed, the court then hears oral arguments in cases from October through April. The court is very, very formal at this point. The court martial, okay, let me explain this to you. When the court is in session, the road judges make a formal entrance into the courtroom for a standing audience and the sound of a banging gavel. The court martial then presents them with a traditional chant. The Honorable, the Chief Justice, and the Associate Justices of the Supreme Court of the United States. Oyez, oyez, oyez. All persons having business before the Honorable, the Supreme Court of the United States, are admonished to draw near and give their attention, for the court is now in session, is now sitting. God save the United States and this honorable court. Now, again, we say God in this circumstance, and this is the thing people don't seem to understand. The reason that God is given the under God and the pledge, may God save the Supreme Court, the prayer in the Congress, it's understood that God in this case is not the Christian God, the Jewish God, the Hebrew God, the Muslim Allah. It's not like that. It's the acknowledgement of a higher being while still acknowledging that freedom of religion exists. So you can still say under God and represent atheists, and you're just acknowledging the presence of a higher being for individuals. It's not a call to Christianity, like some seem to believe it is. During oral arguments themselves, each side's lawyers had 30 minutes to make their case. During these cases, the judge or the justices can interrupt the lawyer with questions. The justices seem to take this time as an opportunity to get answers to questions they might have. When the United States is a party, the Solicitor General or one of their assistants will argue the government's position. Once the oral arguments are completed, the justices then retire to decide the case in conference. It's twice a week when the court is in session, once a week when it's not. The conference sessions serve as periods where not only are existing cases heard, but it also serves as the justices' time to entertain petitions for certiorari for other cases. The book is a little bit behind in that they still don't allow cameras into the chambers, but during COVID, they were actually live streaming, and actually still now, I think there are places that you can go and listen to live streaming of the oral arguments. When the courts have made their decision, there are two different opinions made after the vote is taken. So a 5-4 decision, a 4-4 decision, depends on how many justices are in the decision-making process. Whichever side has the majority publishes the majority opinion. If the Chief Justice is in the majority, the Chief Justice decides who writes the opinion, including themselves. Otherwise, the most senior justice in the dissenting group can assign a member of that group to write a dissenting opinion, which is the other side. Ruth Bader Ginsburg was made famous for the I dissent, or I respectfully dissent. Logic in the court's rulings. If a justice agrees with the outcome of the case, but not with the majority's reasoning, that justice can also write a concurring opinion. All opinions are announced publicly before the court adjourns for the summer. Let's see, again, usually in June. Let's see, this judicial actions and judicial restraint. I think we've already kind of talked about this. We kind of already talked about how the public opinion affects these things, and I should probably talk about how the court talks about how it interacts with law, but okay, we're going to talk about that in lecture 2. think that I've given you enough, and we'll talk about how in lecture two we'll talk about the court and the other branches of government, and then we'll talk about the lower courts and the state courts and how the courts are divided in 13.2, and then we'll call it a day right there. So we'll call lecture one done right here.